Kakamega is fine. The rains are about to start.
Very good.
Yes.
So we'll start with a very quick introduction. My name is Martha Kome. I'm the chairperson of the JAC, and I welcome you for this interview.
Thank you.
Good morning. Or almost afternoon. Isaac Ruta is my name, and also Vice Chair.
Afternoon, Your Honor. Jacqueline Ngutia, Commissioner. Welcome.
Good afternoon. My name is Charity Kisotu, a Commissioner. Welcome.
Good morning. Mwanza Umbati, karibu.
Good morning, Joken Ndungu.
Good morning, Mheshimiwa. Fatuma Sichale, Commissioner, karibu sana.
Thank you.
Good morning, Mheshimiwa.
Good morning.
Olwande Evelyn, you are welcome.
Thank you for the introduction. Mheshimiwa, can you start by telling us your county and your ethnicity?
I come from Kakamega County. I'm a Luya.
Very well. If you could start by telling us who you are, what you've done in terms of experience and knowledge, expertise, that makes you think that you are suitable for the High Court, and what values you bring to that court. You have 5 minutes.
Thank you. My name is Josephat Burudi Kalo. I'm an advocate of the High Court. I was admitted to the bar in 1998, after which I practiced for about 2 years. I then joined the Kenya Bureau of Standards, where I worked for 10 years. Briefly, I joined practice. Then adverts were made for the judiciary. I applied, and I was recruited as a chief magistrate in 2016. I have served in Nakuru and Mombasa, and currently I'm a chief magistrate at Malindi Law Courts. Academically, I hold a bachelor's degree in law. I also hold a postgraduate diploma in law from Kenya School of Law. I'm undertaking a master's degree at Mount Kenya University. I'm at the stage of defending my thesis. I have gained a lot of experience, both in practice and on the bench, also in the public sector. I've done, I think, very well as a magistrate. In the stations that I've served, I've delivered efficiently. And beside that, I also gained experience in the public sector when I worked as the Corporation Secretary at Kenya Bureau of Standards. I'll bring collegiality, I'll bring a legal experience, and I'll bring a lot of hard work if I'm appointed judge of the High Court. Thank you.
Very well. What are the challenges that are facing the High Court right now?
I think currently we have a challenge with the backlog of cases, and also which affects timely delivery of justice.
Yes, even where you are, we have challenges of backlog of cases. So what would you bring to the High Court that would hand value to it?
If I'm appointed judge, and to ensure that we reduce on backlog, I will insist on a very thorough pre-trial process, where if matters can be resolved without going to trial, then they're resolved at that stage. Those that would require to go to trial, I'll ensure that issues are very clearly identified so that the trials don't take a very long time. We just deal with the issues that have been identified, and with trials that don't take long, many matters can be handled within a short period. Thirdly, I would also utilize AJS. I would refer matters to mediation where possible.
Yes, all those mechanisms are there. So I'll hand you over to my colleagues, Commissioner Mwanza, to find out how you have used those in your station to show that you are ready for promotion to the High Court.
Thank you.
Thank you, Chief Justice. Mheshimiwa, you've heard about the term intersex.
Yes.
Intersex.
Yes.
Yeah. What's your understanding of it?
Intersex is a person who is born without a clear assignment of the gender.
Yes.
It's not clear whether it is male or female.
Okay.
It is something in between.
Okay. Now, there was a bill that was proposed by Parliament, but it's yet to pass. But there's something interesting about that bill that I just want to hear what your views are. Section 14 of the bill 1 provides that a marriage involving an intersex person shall be celebrated in line with the Marriage Act. Okay?
Yes.
Then subsection 2 provides that an intersex person who intends to marry shall, on request by the Registrar of Marriages, provide a medical report issued pursuant to section 11 of the Act or any other supporting document. Would you, in your view, would it be constitutional to ask an intersex person to provide a medical report before their marriage is authorized by the registrar?
I don't think so. That would amount to discrimination based on their sexual orientation.
Intersex is not sexual orientation.
Okay, based on their sex. Sorry.
Yeah.
Yes, based on their sex.
But then how would you reconcile that with the definition in Article 45 of the Constitution, which provides that the family is a natural and fundamental unit of society and necessary basis of social order, and shall enjoy the recognition and protection of the state? And more importantly, for my question, every adult has a right to marry a person of the opposite sex based on free consent by the parties.
Okay.
So you, on one part, you are saying that an intersex person is not in the binary specification of whether one is female or male. Sometimes it's in between.
Yes.
But whereas that is the definition, the legal definition, or the accepted definition, the Constitution seems to suggest that the right to marry only belongs to those of the opposite sex. So how would you then reconcile that with those who are intersex?
All right. I think intersex people are normally raised either as a girl or as a boy. That one is normally a choice that is made by the parents at birth. In many cases, for an intersex, some organs are more pronounced.
What if that choice is not made by the parent?
Then the person themselves would then decide whether they are getting into the marriage as a man or as a woman, depending on which of their two sexual organs is more active than the other. So,
but you are presuming that that marriage for these people will just be based only on the basis of sex.
Yeah. So my point is, it will be their own choice to decide whether they are that they'll get into the marriage as a man or as a woman. But I wouldn't advocate for a medical report, because still the choice would still remain theirs.
Okay.
As they get into the marriage.
All right.
Thank you.
Now, in certain instances, you find litigants who are extremely contumelious or vexatious, and those instances sometimes trigger the Attorney General to move the court to declare a litigant as a vexatious litigant. Mheshimiwa, can you tell us what would be the conditions that the court has to be satisfied with before it can declare somebody as a vexatious litigant, and that what will be the effect of that declaration in terms of Article 48 of the Constitution, which provides that the state shall ensure access to justice for all persons, and if any fee is required shall be reasonable and shall not impede access to justice.
All right. Now, a vexatious litigant is a litigant who comes to court without serious issues for litigation, and they keep bringing them up now and then. So, for one to be declared a vexatious litigant, number one, it must be established that they have filed multiple suits, and then secondly, that the issues that they're pursuing are actually non-issues as such. They're just there to waste the court's time and also to waste, to vex the people they are taking action against. If those conditions are met, then the AG can apply to have them declared as such.
But then what happens to their right under Article 48? Doesn't that also deprive them the right to access to justice under Article 48 of the Constitution?
That decision does not derogate from the right under Article 48 in my view, but that is not an absolute right. It has limitations, and one of them is exactly what we've just discussed, that you're a vexatious litigant. You've not been denied access to the court system, but because of your conduct, you are declared a vexatious litigant. So it's a qualification
on the right.
On the right.
All right. Thank you.
Thank you, Honorable Chair. Mheshimiwa, one or two questions from me. Yes. Public participation. Article 10, sub-article 2, lists public participation as a national value. In terms of what it was intended to achieve, can you say that it has achieved?
Thank you. As correctly pointed out, public participation is now a national value. All decisions that have a public bearing must be subjected to public participation. It's at its nascent stages in the country. Of course, it's been running for a while, but it cannot be said to be perfect at the moment. In fact, currently, and the courts are about to intervene on this, it is taken more of as a ritual, just to conform with the constitutional requirement, and not necessarily to inform the decisions that are made. In many instances, public participation will be conducted. First of all, the sampling will not be determined, how the sample is determined. And then secondly, even the outcome, the opinions that are collected out of that public participation do not always inform the decisions that are eventually made as required by the law. So I would say it is still a growing area. We are not yet there, but we are getting there slowly by slowly.
I've heard you say that it is performed more as a ritual. So, of course, what you're saying is that it serves no useful purpose.
Yes, in a number of instances, public participation will be conducted on an issue, but it will not inform.
So it's just a ritual. It's just a ritual that is being performed. Then, in your view, what then would be active and meaningful participation for us to be able to realize this national value?
Yes. I think for it to be achieved, we must come up with rules and regulations on how public participation should be conducted. Number one, how the population should be sampled, who should participate. Number two, what questions are put out to the people participating. And 3, how the views are collated, and 4, how those views then inform the decisions that are being taken. I think in the absence of such rules, it is not really clear how public participation would really inform decisions. So my answer is, we require rules and regulations on how public participation should be conducted.
All right. So, in a nutshell, what you're telling us is that those are some of the challenges that are faced when one is undertaking, when either public participation is being undertaken either at national level or county level.
Yes.
What about the question of citizen apathy?
Thank you. Yeah, it's quite prevalent, and it flows from what I've explained earlier. If people were to come up and oppose, say, a government project, maybe they deem it not useful for them, or there is another competing one which they believe should be undertaken, but the same still goes ahead and is undertaken and finances are expended, there would be a feeling that their views do not matter when it comes to implementation of projects, and therefore that's what I would say would result in apathy.
All right. A few minutes ago, the candidate who was there before you, we were talking about the powers of a governor in a county government, and we came to the conclusion that a governor can hire and fire, although of course one must then look at the provisions of the Employment Act as well as the Constitution. Now, you know that a deputy governor deputizes the governor of a county government.
Yes.
Does he or she also have the same power to hire and fire?
No, they don't have. Deputy governors don't enjoy executive power.
The deputy governor doesn't enjoy executive power. I thought the deputy governor is deputizes the governor.
In fact, it is expected that the governor would allocate duties to the deputy governor. But the law does not precisely set out the role and the functions of a deputy governor. So they do not
Would it be in order for a deputy governor to say, since I'm your right-hand person, the number 2 person as it were, and since you're vested with power to hire and fire, I can also do the same?
No, that would be against the law, because that power actually is not even it cannot be assumed. It cannot be delegated to the deputy governor.
Fair enough. Mm-hmm. Thank you, and that's all.
Thank you, Chair. Good morning once again, Your Honor.
Good morning.
Would you need to take some water break, or you're okay? We can proceed.
I'm okay. I'm okay.
Okay, thank you. I've gone through your sample writings. You've shared decisions in civil, criminal, ELC, and ELRC matters. They reflect measured judicial restraint and reveal a purposive and contextual interpretive approach. They are coherent, and it appears as though you value legal certainty, procedural propriety, and practical justice. You make use of precedents well, and you also apply statutes consistently. So I applaud you for a good job well done.
Thank you.
I'll ask you a question in the form of a scenario with regards to matrimonial property. So a man marries a woman, takes the woman to the village, and they put up a house in the father-in-law's homestead. So the man then returns to a city and leaves the woman in the parents-in-law's home. So the woman undertakes business in the shopping center around the husband's place, and out of the proceeds of that business, she's able to support the husband to put up a house in the father-in-law's homestead. After 20 years, they divorce, and the woman now claims part of her share of what she supported the husband build, including the other developments within that homestead. At the time of the divorce, the father-in-law had died, and part of that property had been given to the husband through succession. Does the woman have any recourse under matrimonial property?
Okay, thank you. I think the basic principle about matrimonial property is that there must exist a marriage, and the marriage must terminate. It's upon termination of the marriage that the issue of matrimonial property arises. I'll start on that basis. From your narration, it is apparent that these developments were done on land that was owned by neither of them, neither the husband nor the wife. It would therefore be difficult for the woman to claim matrimonial property on two grounds. Upon the demise of the father-in-law, that property became the subject of a succession process for the fact that I've explained, that they constructed on the father-in-law's land. So that being the case, the issue of matrimonial property cannot arise, and as such, the wife, as it were, may not be entitled to matrimonial property. Thank you.
I said before the divorce, they had had the land transferred through transmission. So at the time of the divorce, the land was registered in the names of the husband.
Right. Then,
but at the time of development, it was registered in the name of the father-in-law. It's a common practice anywhere across the country, where you marry and you establish your home in your father-in-law's place.
Yes.
So at the time of divorce, the property was registered in the name of the man, the husband.
Okay.
So the woman is claiming that she needs to be considered on the development she's made and the support she has accorded the husband, who was away in the city, and she's the one who was working to develop the property. Yeah.
Okay. May I seek a clarification? Who is dead? Is it the husband?
The father-in-law.
The father-in-law.
And subsequently, through transmission, the husband gets registered as the owner of that portion of land through succession.
Through succession.
Transfer of property
Okay.
after death is transmission, yes.
Okay. All right. Then in that, with that explanation, it must be noted that the property was transmitted to the husband by way of succession.
Yes.
Right? So that at the point this lady was making contributions, the property did not belong to the husband and therefore could not form part of matrimonial property. The transmission.
What recourse does the lady have? She can show you that for over the years she's been supporting the husband. The husband was away in Nairobi. She ran a big business in the village. She even has receipts of the funding she was engaging. Does she have any recourse? Or you just tell her, sorry, go back to your parents with nothing?
Yeah. Unfortunately, that's the situation that is prevalent today, and the law only recognizes the scenario I've explained, that matrimonial property can only ensue if at the time of contribution this property was owned by either both of them or the husband.
Outside matrimonial property regime, is there any other recourse she can get?
Yes. Now, outside the matrimonial property, I think having resided on the land and having developed it, she can claim a part of it as part of the succession process, but not as a matrimonial property.
Okay. Yes. My last scenario, a property is registered in the wife's name, and in her lifetime, she cannot sell or charge it unless she gets consent from the husband. Sadly, the wife dies. And the husband says, I need a claim of matrimonial share before the other part is distributed to other beneficiaries or dependents. How will you handle that case?
Now, if that scenario were to present itself, my argument would be that that property is no longer subject to Matrimonial Property Act. It is now subject to succession, and therefore a claim under Matrimonial Property Act cannot hold.
The law of succession describes an estate as free property of a deceased person.
Yes.
So is matrimonial property free property upon death?
It is, as long as before death it has already been determined that it's your share, right?
Okay. Are you aware of any Court of Appeal decision that has handled the issue of matrimonial property in succession?
There's a recent decision, I can't recall it offhand, but I think the court held that one has to prove contribution, even where they are claiming under succession. But I can't remember it offhand.
Okay, thank you. Thank you, Chair.
Thank you very much. Justice.
I want to test your knowledge of the jurisprudence of the Supreme Court. Let's talk about public participation. In the parliamentary process of consideration of bills, at which stage must Parliament conduct public participation, and why?
Thank you. Now, public participation, in my view, should be conducted after the first reading, because that's when views are invited from members of the public on the bill. The bill has been crystallized, it has been presented before Parliament, it has gone through the first reading. At that point now, views are normally invited from members of the public to conduct it. I think that's the best point at which public participation can be undertaken.
Okay, so what happens if the public give their views and the members of Parliament wish to make changes based on those views? Should the changes not be subjected to public participation? How will wananchi know what is the difference between the bill as first published and the bill after the initial public participation, if there are any changes?
Yeah, because after the first reading, any proposals are normally incorporated into the bill before it goes to the next stage.
You see, when Parliament conducts public participation, they invite the public to make a comment on the bill.
Yes.
So after the public has made comments on the bill, they can change the bill.
Yes.
How will the public know what changes have been made?
After the changes are incorporated, I think the bill,
For example, you might be satisfied with the way the bill looks, except that you want one part to be changed. But you are not aware that somebody else has made a suggestion for an amendment of the part that you are okay with. So then what comes out is not what you thought you had seen. I don't know if you're getting me.
yes.
So, should those changes be subjected to public participation? How or should the public be informed?
I think maybe is after views have been collected and incorporated, the bill must be published again.
Okay.
To show whether those views have been, to actually show that what the public intended has either been incorporated or has been rejected with the reasons.
Okay, yes, with the reasons, isn't it? Yes. Okay, let's move to electoral laws. Now, you know that before an election, for example, a political party will give a list of their candidates in each of the electoral units. They'll also give a party list for those who are party list MPs, to be party list MPs, depending on the number of votes that the party will achieve at the election. Can the IEBC alter the party list?
No, it cannot.
What if the party...
Okay, let me correct myself.
Yes.
The purpose of the party list is to take care of several interests, including vulnerable people, youth, women. So if a party list does not conform to those requirements, then the IBC would return it to the party, would reject it,
Okay.
but not amend it.
That is correct.
Yeah.
But what if there is a name on the list which contains a name of somebody who does not contain the qualifications for Member of Parliament? For example, maybe the person is a member of a county assembly,
Yes.
and has been included in the party list for
Yes.
the National Assembly. Can the IEBC alter the list?
It would just reject it, because
Okay.
altering would mean replacing that person without use of the party machinery, which...
So it can return,
Yes.
it will alert
It
the
will
party.
return.
But what if the list has already been gazetted? Can the IEBC then, can somebody raise the issue with IEBC?
Yes.
And what would then happen? The IEBC has already received the list, it has gazetted the list, and then the complaint has been made. What ought to happen?
IBC enjoys a quasi-judicial power. They have a mechanism of dispute resolution, and by use of that, and after hearing both parties, they will then arrive at a decision. In this case,
But if they've gazetted, would the dispute then be a pre-election dispute? Or would it have to be a dispute that goes to an election petition?
I think after gazettement, that it becomes an issue,
An issue for the election
for the
petition.
election petition.
Okay, thank you very much.
Yes.
Thank you, Chair. Good morning once again.
Good morning, Madam.
Yes, I have your performance report here from DISPOP.
Yes.
I'll not ask you a question about it. The report is good.
Okay.
You seem to be carrying more than what is expected of you. You're expected to carry 7%. I see here you are actually doing 9%, 2 more than what is expected of you, which is commendable. I also see that your station is doing quite well. Case clearance rate is above the national average as well as the court productivity. So I commend you for the good work as part of a team and also at the individual level. Now, the question I have for you is a scenario. Imagine you have succeeded in becoming a judge. Day one, there's a plea before you, a murder plea before you. Walk us through the steps that you would take, the things you look out for, and the reasons for the decisions you will make or the directions you will give.
Okay. When a person is presented court for charged with murder, before plea is taken, I would refer them to mental evaluation or assessment. Then I would give a period within which they will come back to court with the report. If it is found that the person is mentally fit to stand trial, then I would invite the prosecution to present the charge. The charge would be read to the accused person and would enter plea. If he pleads not guilty, I would consider the issue of bond and bail. And in this case, I would invite submissions first from the prosecution, whether they oppose the release of the accused person on bond, and then a response from the accused person or his defense. Based on the submissions before me, I would determine the issue of bond. And in many cases, bond would be given as a matter of right unless circumstances have been explained why why bond should not be given. I would then set the bond terms, and then I would direct a date for a pretrial conference. And in that pretrial conference, I would direct that the prosecution supplies the accused person and his defense with all witness statements, a copy of the charge sheet, and any exhibits that will be used at the trial. I would then set a date to confirm that that has been done, and it's only then that I would fix the suit for hearing.
Okay, thank you. Now, at the stage where you are considering submissions from both the accused or the defense and the prosecution in respect to bond, what are some of the factors that would lead you to either deny or grant bond?
Okay, now the purpose of bond is to secure the attendance of the accused person. So, number one, I would consider whether there is evidence that the accused is a flight risk. If it's a flight risk, of course, I would deny bond. Secondly, I would consider if there is a likelihood of witness interference, whether the accused has the ability to interfere with the witnesses before they testify. And then number three, I would also consider whether it would be dangerous to the accused person if I released him. Murder cases are emotive, they occur in society. Mostly they are people who know each other, and therefore releasing an accused person would be a danger to themselves. In that case, I would also deny bond. But if none of that is explained, then I would give bond.
Okay, thank you, and I wish you well. Thank you, my lady.
Thank you, Honorable Chair. Mheshimiwa, you could tell us what steps would you take to ensure your court station is corruption-free, is a corruption-free zone?
Okay, thank you. Number one, I would ensure that there is an anti-corruption policy which is documented and which is communicated to all members of staff. After that information, we would also appoint anti-corruption champions to drive that policy at the station level. These are the people who, in the event of any corruption issues, they'll be addressed to they'll be addressed to them. Then they bring to my attention. And then number three, I would ensure that there are notices. This is an anti-corruption-free zone all over for members of the public to be aware that there's no corruption and in the courtroom. I would also provide a toll-free line that is confidential for members of the public to report any cases of suspected or real corruption. Thank you.
And what if you it comes to your attention that your colleague, a colleague judge, is also involved in corruption?
If it comes to my attention that a colleague judge is involved in corruption, I would do a confidential report to the Chief Justice, informing him of that particular fact. Yes.
You'll also not find out, this is a colleague, you'll not find out exactly, these are allegations. So would you also not find out from the colleague what's happening? Try to talk to and discourage the colleague?
Noting that we are at the same level, I would make a report, and I think, as I've said, I'll forward it to the Chief Justice for action.
Okay. Now, how would your colleagues or even stakeholders describe you?
I think I'm a very open person. I interact well with the members of the public and my colleagues. I'm a team player, and I encourage consultation both vertically and horizontally.
Okay.
Yes.
Yeah, the report we have from the public or even from the stakeholders, no integrity issues that were raised, so I commend you for that.
Thank you.
However, of course, they agree that you're very diligent at work, but they say that there are some who say that you have very limited interaction with staff and describe as not a people's person, no active welfare matters, he only attends bar bench meetings?
I think maybe the situation at our court station in Mombasa was such that there was a very heavy backlog. When we got to Mombasa, I think it was at 48,000, and we were challenged to reduce it to reasonable levels. So I spent most of my free time trying to work on that. So maybe I may have seen that I did not attend welfare meetings, but it was because I was pursuing that larger cause. Yes.
Okay. Thank you. I wish you all the best.
Thank you.
Thank you, Honorable Chair. Mheshimiwa, a few questions for you. What is your understanding of sexual harassment in the workplace, and in what forms does it happen?
Sexual harassment in the workplace is a situation where a senior or even a person on the same level tries to take advantage of their juniors sexually. It manifests itself in many ways. Could just be maybe a gesture, an inappropriate gesture, maybe touching someone inappropriately, and it may go as far as demanding for sexual favors from that person.
Okay. And as a leader, if you're successful, what role will you play in protecting the dignity of those who work under your supervision?
Yes, I would ensure that the sexual harassment is dealt with firmly and instantly. I would not allow any cases of sexual harassment at the workplace.
How will you go about that?
Yes, I would communicate very clearly, in fact in writing, that in the event someone feels sexually harassed, they can either report to me, or if I'm the one harassing them, it can happen, then they report to the next senior person whom I would clearly communicate. And I would encourage anybody who feels that they're being sexually harassed to report immediately so that action is taken.
Okay. So that is taking action after the act. Is there anything you can do before?
Yeah. As a preventive measure, I would ensure that the policy against sex harassment is communicated to everyone that works with me.
Okay. Yes. How do you deal with the multiple tasks with conflicting deadlines?
I would delegate. I would also create more time to work on them. And I would also use, in this case, use of researchers and those are available at my disposal.
When you say delegate, what will you be delegating?
Like research work and drafting the draft judgments. I would delegate that.
What will you not delegate?
The actual writing of the judgment and ruling itself, I would honor it.
Okay. You have an employee who keeps absenting themselves from work, and upon investigation you realize that they have an issue with alcoholism. They give all manner of excuses, but when you try to dig, you find that they don't come because they've spent their time indulging. And then you also have another one who is caught soliciting for bribes. Tell us how you'd go about dealing with those two employees.
Now, alcoholism, I think, has been described now by the World Health Organization as a disease. It is no longer an issue of just indulging. So if a colleague is an alcoholic at the workplace, the first thing to do is to refer them to rehabilitation, to try and rehabilitate them before taking any drastic action, because that's actually a sick person who requires help rather than condemnation. As regards solicitation for bribes, that one cannot be excused. I would immediately report them to the police, have them arrested and charged.
Okay. Thank you, and I wish you well.
Thank you.
Yes. Are you relaxed?
Very relaxed.
Ama umechoka? Bado?
Bad.
All right. Is a judge allowed to engage in public collections or harambes?
No, I wouldn't do that. Yes, it could cause conflict.
What are the exceptions to that?
The only exception would be if it involves colleagues like ourselves, then I would participate.
How about in case of a national disaster?
Well, if it's taken as an institutional position, then I would participate as part of the institution.
What are some of the key elements of an independent exercise of judicial authority by a judge?
Number one is to ensure impartiality. Number two is to avoid conflict of interest. And number three is to act in accordance with the law and the code.
Okay, thank you. Wish you well.
Thank you.
Okay, thank you very much, Commissioners. Mheshimiwa, I think this almost brings us to the end of this robust interaction with you. But I would like you to answer one question on a general one. How you think the High Court in particular, has protected the value of devolution.
Thank you.
And if you have any cases that the High Court has decided in that area, you can tell us.
I think the High Court has robustly made pronouncements on case law that have been brought before it, where the national government appeared to trespass into the mandate of the county governments. It has clearly specified, and it has clearly made it clear the roles. It has defined the roles both for the national and county governments as set out in the Constitution. And I think that really has helped protect devolution.
Okay.
Unfortunately, I didn't.
No
read
case
about
comes
that
in
case, no
mind.
case comes
But
in
what are the objects of devolution as per the Constitution? If you can name just 3 or 4 of them.
Yeah. Number one is to ensure that power is devolved from the center. Number two is to devolve resources to the counties. And number three is to ensure that people on the periphery plan for their own development.
Mm-hmm.
Yes.
Okay. Very well. I'll take those 3. I think now it's your turn to engage us because we have been engaging you.
Mm-hmm.
So we always give a candidate an opportunity also to engage us.
Okay. Thank you for this opportunity. I was very elated when I was shortlisted, and I believe that you'll grant me an opportunity to serve as a judge of the High Court. Thank you.
Thank you. On behalf of the commissioners, we wish you well, and we always encourage candidates, because this is a very competitive exercise, to keep doing the good thing that you're doing. Keep serving the people of Kenya. So we wish you success.
Thank you.
We will get in touch with you when we complete the exercise.
Thank you so much.
Yes.
Thank you.
You are released.
Okay.
You can